What did you say the light does, John? Did you sorry, Paul. Can you tell us again? Okay. But you're going to do that for the total.
All rise and give your attention to the Honorable Justices of the Montana Supreme Court. This court is now in session. Morning, everybody. This is the time set for oral argument in cause number DA 23-0716, Rodney Brandt and others versus R&R Mountain Escapes LLC. So I understand Mr. Frampton will be arguing for the appellants, is that correct? Sorry, appellees. And Ms. Bacchus will be arguing for the appellants. And then I have a note here that you want to split your time, so saving 15 minutes for rebuttal. Is that accurate?
If I may, Your Honor.
Yep, that'd be fine. All right. Ready to proceed.
May it please the court, and good morning. I'm Stephanie Bacchus here on behalf of the appellants, R&R Mountain Escapes, it's completely owned by Dr. Russell Palmer and Ramona Stewart. Ramona Stewart is here with us today. Also here are amicus parties who have filed briefs in support of the Palmers, including the Landlords Association and the Bridger Canyon Property Rights Coalition. Thank you for inviting us here to address these important issues for our state, which involve important questions of contract interpretation, the scope of property rights, and contract construction. Not only are these questions important for the Palmers and the plaintiffs, they're important for Montana homeowners and tenants because residential homes in our state, most of them, have some form of residential covenants that apply to them. I'd like to emphasize three main points in my argument today. First, there are two undisputed facts in this case that resolve the case in appellant's favor. First, the covenants allow rentals, and second, the covenants have no language about duration. We contend that this makes the covenants unambiguous. Second, our theory of the case is consistent with precedent, including Craig Trax and its progeny, like Myers v. Kleinhans, whether or not the court finds the covenants ambiguous. And third, this case is critical to upholding Montana's historic protection of fundamental property rights. Not only is rental use one of the sticks in the bundle of property rights, but short-term rental use has been around since the founding of our country. And if the district court's decision is not reversed, this case could have wide-sweeping and destructive impacts for thousands of Montana homeowners in the rental context and otherwise. Upon the first point, there are two critical undisputed facts. First, we think these facts make the covenants unambiguous, but at a minimum, they create an ambiguity that must be resolved in appellant's favor. Unlike the court's recent decisions in Craig Trax v. Brown Drake or Myers v. Kleinhans, in this case, the restrictive covenants at issue permit rentals. The terms expressly contemplate rentals in the section A6, which is about advertising, and it's talking about signs. It allows signs, advertising billboards, and advertising structures for sale or rent. And the plaintiffs themselves use their property for long-term rental.
Could I interrupt you for
Of course.
a minute? So the covenants also say only for residential purposes, not commercial. How do you address that? I understand your argument with respect to the rentals, but the covenants also say not for anything commercial. And Myers.
So, Your Honor, thank you for the question. We certainly contend that the short-term rentals that the Palmers have been doing, which were a minimum 5-night stay, the Palmers themselves stayed in the property for 8 weeks of the year. 27 nights maximum that they had it rented out in '23. Those uses, when the renters are there, are the same as they would be when the Palmers are there. They're eating and bathing and sleeping, recreating, relaxing, potentially doing a little bit
But
of
how
work
is
at
that
night.
not commercial? I mean, we've found in Kleinhans that short-term rentals are commercial use that violate a covenant that says no commercial use. So I know that we have the rental covenant, and then we have the no commercial use covenant. How do you weave them together to give both of them meaning?
Right. Well, so the definitions that the court looked at and the set of particular covenants in Myers v. Kleinhans were different than they are in this case. In this case, we have a specific set of provisions, one of which is to expressly allow rentals without any reference to duration. And so if you're going to read the covenant and the contract as a whole, which is required under standard principles of contract construction, you have to do that in a way that makes those provisions harmonize. And in order to do that, you need to look at what the drafter intended by the definition of commercial. And so the definitions that this court looked to in the Myers v. Kleinhans case would also prohibit long-term rentals in this case. And we know that that's not going to be possible because there is a provision that contemplates rentals. So the type of commercial activities are further defined by the drafter's intent. You can see in the provision regarding commercial use where it talks about such as. It says that commercial uses are prohibited. It says such as junkyards and mobile home
But
parks.
it also says et cetera, right?
Correct.
And also it says whatsoever. So, I mean, no commercial use whatsoever seems very broad to me. I mean, to get it, the intention.
The appellants don't disagree that the commercial use prohibition is somewhat broad, but it can't be read to prohibit rentals. The plaintiffs and the defendants, or appellants and appellees, both agree that long-term rentals are permitted under the covenants, and there's no difference between a rental of 28 days and a rental of 31 days. The court in the district court, pulled a 30-day limitation out, and it created that limitation onto the contract. There is nothing in the contract that talks about that. And again, the rental use that is being done by the guests or the renters that the Palmers have at their property was the same as it would be no matter what the duration.
Let me follow up on that, because I think they make the point that that's regulatory based on the county's use permit, and we'll address that later. But I want to go back to what Justice Gustafson was talking about. So the prohibition is any other commercial, it doesn't say use, it says purpose. Prohibits any other commercial purpose whatsoever. So whatsoever is a pretty broad term. What do you make of, first of all, the word purpose versus use there? And then I have a follow-up question.
So when I read the word purpose there, especially considering the inclusion of the four junkyards, junk and wrecking lots, mobile home parks, I see that as defining the type of business that is happening there. Specifically, it does also say, trade or manufacture. The Palmer's home is a single-family residence. It is more residential in its nature when it's rented than the home was in Craig Tracks. In Craig Tracks, you had a fishing lodge that was rentable by 3 different parties at any given time. This is a one single-family home. Additionally, the long-term rental is identical in many of its features to a short-term rental, and those are the significant ones that the court looked to in the district, and those apply equally to long-term and short-term, such as being advertised on national websites, having property management, and also, having the ability to earn income. Surely this court needs...
But a difference between a long-term and short-term rental, right, is, for neighborhoods, the issue of people coming and going, knowing who their neighbors are. I have a long-term 6-month rental. It's like I have a family that functionally can act like they own the place. Where if every 3 or 4 days I have new people driving in, new cars, lots more traffic because they're bringing people with them. Lots more in and out with their stuff. There's quite a bit of difference between a long and a short-term rental depending on the number of days, right?
So if the covenants were to want to define short-term and long-term rentals, they could do that. But here in this case, the covenants do not do that. There's no durational threshold. So to the extent that you believe them to be somewhat different, you have to harmonize the ability to rent, which is allowed in the covenants, with that commercial use prohibition. So we don't have the ability to draw these lines that you might in a public policy.
If we're going to do the strict construction of the terms of the contract, you've got the use clause that says no commercial uses whatsoever, no commercial purposes whatsoever. You're hanging a lot on a signs clause. It's not permission to rent, it's permission to put a sign on your yard. And they're advertising worldwide on the internet through VRBO and Airbnb. So, we're talking about the drafter's intent, and I have kind of a tough time envisioning Edna May sitting there and looking at this and thinking, yeah, this is going to be, in 1990, this is going to allow people to come in and rent it 5 days at a time. If they want to put a sign that says for sale or rent, that's what's allowed by the terms of the covenant.
So with all due respect, I think what you're describing is a classic ambiguity. And if you think that these covenants, create any sort of tension, then what you need to do is resolve the ambiguity that's created by them.
No, I'm saying it's not ambiguous. I'm saying they have the right to put a sign in their yard that says for sale or rent, period.
So what I would say is that in your scenario, that the provision regarding signage is evidence as to the drafter's intent, because the drafter included that language in there. There's also wording in the covenants about...
And the intent is to put a sign in your yard that says for sale or rent.
So the fact that the sign can advertise rental, in a resort community like Whitefish, I don't think that we know whether the drafter intended that to be, a sign for weekly rental for people to enjoy the beach. I think that we don't know, and that's why you're in a situation under your scenario that it is at a minimum ambiguous.
Well, no, so put the sign up and see how that works. She wasn't envisioning internet advertising in 1990.
Well, she talks about billboards.
And on the use part of it, the part of the contract, or the covenants, that specifically deals with uses, says no commercial purposes, and gives some examples with the tag, etc. This is a commercial purpose. The part that you're pretty much exclusively relying on is a clause that deals strictly with what type of signage can be used.
So I would say that, again, we're not exclusively relying on that. I think that it is evidence of the intent that rentals are allowed, but also in this case, no one reads, the district court, the appellants, the appellees, no one is reading these covenants to prohibit long-term rentals. And so because of that...
In response to a sign.
I can't speak for the district court or the appellees. I can speak for the appellants that we believe the covenants, given that the way they're written, where they talk about corporations owning property, they talk about, they did know how to limit. They do know how to create distinctions and differentiations. They do that with sort of agricultural use, right, where they talk about no swine and no pigs. They didn't choose to do that here.
I'm sorry, excuse me, but as far as the intent goes, though, too, you're relying a lot on Craig Tracks, and I see two critical distinctions between this and Craig Tracks. One is we put a lot of import on the fact that in Craig Tracks, prior to this dispute arising, that they had removed the prohibition on commercial uses from the covenants, and we noted that was indicative of an embracing of allowing a more liberal construction or a liberal use of the property. And in this case, then, shouldn't we ascribe the similar importance in the fact that this prohibition has been in effect from their inception in 1990 and nobody has ever removed them?
So I think there are two things I'd like to say in response to that. The first is that in the Craig Tracks case, the covenant that was removed was contemporaneously removed, basically, to the time of drafting. And so I think it is relevant to learning about the drafter's intent. Here, the covenant is different here, that it was the one that was removed in Craig Tracks, talked about apartments and hotels. That's not the same thing as the provision here. I think the critical piece to know is that every set of covenants is unique. And I think that when you get into a situation where you're trying to read a covenant in a way that's bending into a pretzel, you're trying to figure out how to harmonize these, I think you're in a classic ambiguity. And when the ambiguity arises, then you follow the rules of contract construction, which is that if there is extrinsic evidence contemporaneous to the drafting, which there was in Craig Trax, but which there is not here, then no one has offered any contemporaneous evidence in this case.
Let me ask you a question. Let's assume for a moment you're correct, that this is rental residential purpose. Tell me the scenario where this would be commercial. Like what level of renting scale would we achieve before it becomes commercial?
So I don't believe that the rental of a single-family home under this set of covenants could ever be commercial.
Tell me what the scenario is where it would be commercial. Would it be Craig Trax, as many rentals as that had with the fishing lodge?
So again, I don't think we can draw lines like that. I think the
Well,
rules,
I'm asking you to draw the line. So where is it, if they have 100 homes?
if you tore the home down, you tore the single-family home down, and you built a hotel, that would certainly be in violation of the covenants.
Okay, what if the owner has 100 homes that they rent, short-term rentals spread across the country? They're clearly using it for commercial purposes, even though they're all residential homes. Would you agree?
So I don't think so, if I understood your question correctly. I don't think it matters how many other properties the owner of the home has.
So only the rental covenant, basically, we throw out the other one, because it can never be commercial. We're precluding commercial. They're getting money for these things, which we have found in Kleinhaus hands to be a commercial use, short-term rental to be a commercial use. But under your theory, we're going to give no meaning to that portion, or throw it out, say it can never be commercial, and the rental covenant supersedes everything else.
I don't read the covenants that way. I think that there are certainly things that could be commercial that are not related to renting a single-family home, if I understood your question correctly. But I think you have another follow-up. Sorry, Your Honor.
No, I was just thinking, I put it on the internet, and the 3 families, somebody rents it, they bring 3 families, they move in for 4 days. That's not commercial use.
So I think in that case, you would be in violation of the covenant because it requires it to be single-family residence. And if you bring 3 families in, I think you're going to be violating another
But so
provision.
now they
Yeah.
have to figure out, like, what if we're all related? Like, I bring my cousins and then my grandma, and, they're different parts of my family, but I'm still related. That okay?
So if there is one rental, then I think it's no different than if I have my family come in for a reunion over the weekend, and I have my cousins and my daughter's friends, and, these kinds of things
But
happen
if
in a
it's just my
residential
good
community.
friend that is like my sister, then that violates it. But if it is my sister, then I'm good.
So the covenants in front of us today are regarding, this particular set of covenants, and the provision about commercial use and residential use has particular language, and that covenant has to be interpreted because this is a matter of contract interpretation. So I don't know that I agree with the situation if I followed the facts.
Counsel, could I think we're running into your rebuttal time.
Yeah.
So I can wait and ask it later.
I'm happy to answer.
Okay, this is kind of a follow-up on Justice Shea's question. If we were to find an ambiguity in the covenants, what significance, or could the district court consider the fact that the appellees rented their residence for, I think it was several years?
I believe the appellees are renting now, but I don't think that you can consider that when deciding what the covenants mean. I think it's significant just to inform the court that everyone agrees that long-term renting is okay. Our point is that there's no difference between the long-term and the short-term. I do think it's important to get back to the principles about how you cannot imply a limitation in a set of covenants, like the HEIDI case in 1975 and Krajacek, v. Great Falls and Creveling, which, by the way, the court in that case would not impose a temporal limitation in front of the words that were in the covenant. It was regarding the placement of RVs and trailers, and the court refused to add the words temporary or permanent in front of it. I think that's really significant.
Well, so you're saying that the fact that that the appellees are renting on a longer-term basis has no place in the extrinsic evidence if we were to find an ambiguity.
I think it doesn't relate to what the covenants mean. I think it relates to what the parties' positions are. Thank you.
So counsel, just since you mentioned Krajasic, I mean, we also said in Krajasic when we were talking about contract interpretation that we will not isolate certain phrases of the instrument to garner the intent of the parties, but will grasp the instrument by its four corners and in light of the entire instrument.
Right.
It seems to me the only thing that in this contract or in these covenants that seems to support your position is what kind of sign you can put on the yard, and you're isolating that to garner intent that would vitiate the clauses that say single-family dwelling, residential purposes, and no commercial purposes whatsoever. How is that not, I mean, what else in that contract besides the clause that is explicitly dealing with what kind of sign you can put on your yard supports in the contract, supports your position?
So number one, it's not possible to remove that covenant. It is in the contract. So, and that's a hypothetical.
No, I
But
get that,
do-
and I'm sorry, I don't mean to interrupt you, but I'm talking about not taking that clause in isolation to vitiate all of the other prohibitions against commercial purposes.
So the second point that I would make in response is that I don't believe that it's a fair reading of this set of covenants that it would be prohibiting a short-term rental of the nature that the Palmers have been doing in this case by reading that set of commercial, the language in the commercial use and residential use only covenant is not the same as it was in Myers v. Kleinhahn. It's not the same, of course, as it was in Craig Trax either. In this case, we have a little more information about the intent. It says, such as junk or wrecking yards, mobile home parks, et cetera. So I do believe that it is not an accurate or fair reading to say that short-term rentals that the Palmers are doing would violate that either way, but I think that you have to look at the covenant as a whole, and you can't extract pieces of it that are inconvenient. I think you have to find a way to harmonize the covenants. And so that's why we look to HIGDM, Krajasic, and also statutes regarding reading the covenants as a whole. There was the K&R Partnership v. Whitefish case. Additionally, the rule about interpretation is, of course, that covenants are strictly construed because they're inherently restrictions, right? They're inherently restrictions regarding property use, and so they must be strictly construed. And in the case like we have, where there is no extrinsic evidence about the drafter's intent, you have to err, I would say, that the tie in Montana, when there's an ambiguity, the tie goes to the free use of property. And that's why the rentals in this case, the nature and the facts in front of you, that it has to be read to permit those short-term rentals. So I'd like to reserve time for rebuttal, please.
Thank you.
Thank you.
Good morning, Sean Frampton for the Appellee, plaintiffs, neighbors. May it please the court. There are actually subdivisions and neighborhoods in this state that want to protect and maintain the community that they bought into, and they do not want to be subject to frequent and different and transient neighbors every few nights throughout the year because somebody from out of state bought a piece of property and decided to market it on a website. And Craig's Track provides that protection. The district court followed Craig's Track's lockstep. And R&R's entire argument, the appellant's entire argument, avoids Craig's Track's. While this case was on appeal, Myers versus Kleinhahn was decided, which also protects it by finding that short-term rentals are a commercial use. I want to speak briefly about the issue that I think is presented in this case and maybe in response to Justice McKinnon's questions. What Craig's Tracks did and you guys know it well, but in addition to saying, the majority is saying no duration, just eating and sleeping, the minority says eating, sleeping, and a durational component to it. The court then said in paragraph 13 that we agree with the minority, there has to be a durational role. And then in paragraph 14, you support that finding, that statement as a matter of law with Montana code that says there's a durational component to it. But then in paragraph 15, what the court is saying, the problem is these covenants don't say how long you have to stay there. So the issue presented by Craig's Tracts, which is also the issue in response to your question, Justice McKinnon, is this. I don't think there's any dispute that people can rent their homes in Montana. The question becomes, at what point does the rental become such a short duration that it is no longer a residential use and more of a commercial type use? That is the issue presented with this case and possibly Kleinhans and for sure in Craig's Tracts. And so the issue is not whether rentals are allowed. The issue is at what point is there no longer a residential use to it. So in this case, the covenants, like many, do not say anything about short-term use. No covenants that I've ever read have, about short-term rentals, but they do say there has to be a residential use. And Craig's Tracts held that residential use, that term is ambiguous as a matter of law. So then the court looked to extrinsic evidence. But this is where I think there's a difference in their analysis versus mine. R&R's analysis is this. If there's an ambiguity, then you go towards the free use of the property. That is not how I understand contract interpretation law. What I understand is that when there is an ambiguity, it is the court's job to determine the intent of the drafter. If you can find that intent, then you enforce it. If you cannot find the intent and the ambiguity is unresolved, then you construe in favor of.
Ms. Bacchus told us that there was no evidence or intent of Edna's intent, right? That the record doesn't have that. Do you agree?
I don't agree.
Okay.
And I think that
Tell me why.
Yeah, exactly. I'm going to tell you why. Because this is what the district court did. So the language, and this is, I think it was in the Krasowski case, it's either Krasowski or Kreveling, but the court had said, okay, we find an ambiguity, and then the court didn't go to extrinsic evidence. It immediately went to what the language was in the covenants. So in this case, the court followed that, and they found the ambiguity on page 4, lines 13 to 16. And then in deciding what the language said and what the intent was from the language, the court first did the analysis of the very first thing that this court did in Craig's Tracts, and that is they had removed the commercial use prohibition, suggesting a less restrictive approach. And the court in this case said, because it's there, and again, Klein versus Kleinhaus hadn't been decided yet, so the court said because the commercial use prohibition is there, it would suggest a more restrictive interpretation, which is already the standard by which you interpret covenants, right? They have to be strictly construed. So what the court did is look to the language, and in response to your question, Justice Gustafson, here's what the court said. The court looked at the language, and of course we have the residential use. What I would like to point out is that in the purpose of the covenants in paragraph 2, it's even the heightened standard. If we look at the way we've seen covenants so far in these cases, in Kleinhans, that only required residential structures, said nothing about use. In Craig's Tracts, we show residential use. And in this set of covenants, we have residential living. We have country residential living stated as its purpose, which I think when you strictly construe that, that is different and more tips in the favor of the appellees, my clients, than allowing rentals. So at this point, I would say that we are on par with just that language, because in paragraph 2, it states the purpose, which is country residential living, and then in paragraph 2A, it says that it has to be used for country residential purposes. So at this point, the district court, and this case is on par with Craig's Tracts. if not slightly in our favor. But then this is where the court then interpreted beyond that, and that is the commercial use prohibition. No parcel shall be used at any time for any business purpose, any other commercial purpose whatsoever. If we strictly construe that as Krajewski requires, that would go in favor of intent. The intent is
So,
to not,
but then there's that such as language, so how do you deal with that? Like, weren't they just trying to eliminate dump piles and old vehicles?
I think if the language wasn't so broad, your point would be valid, but I totally get the argument that if it's included, you know, that they're trying to do that, but it's just so broad. If you follow the strict construction required, you can't ignore any business. You can't have, let's say, a construction business operating out of your house and say, well, that's not a junk or a wrecking lot, therefore we'll allow it. You have to construe and follow the strict construction.
Well, but that would also include you can't run cattle for commercial purposes on your property, which your client did.
Did not. Did not. The facts are he ran the cattle on the property that's adjacent to his that are not governed by the covenants. But then on this property, he did have cattle grazing, but if you look at paragraph 6 in the covenants, it's still paragraph 2, under commercial use, it literally says, I'm sorry, it's not coming to me right away, but the exceptions under paragraph 2B so paragraph A is the purpose, paragraph 1 is the land use, and paragraph 1B says that normal agricultural use is allowed. So my client was grazing cattle, which was allowed under paragraph 1B.
So let me ask you a question on this, this list of things here. You've got no commercial purpose, right? You've got no business, trade, manufacture, and we talked about the junk already. So can one of the members of, one of the residents there that are subject to these provisions, can they have any kind of in-home business operated out of their home?
I don't know if that is a question that's part of it, because I think that's a tough question.
Okay, so you're a solo practice lawyer working at home. Is that allowed, living there?
I think if you're having clients appear at your home.
What if you're not? What if you're a remote worker? You work for a firm from Houston, Texas. I understand if this was California, the case would be over, but let's pick another state.
Yeah.
That was a joke. You're a remote worker living in one of these homes. Your full-time occupation is in the home. You don't have people coming and going. Does that violate these covenants?
I don't know if that's related to the rental issue before us, but in answer to your question, I would say no. If you're a remote worker, you're still using your home for a residential purpose. But if you had clients show up, if you had customers, guests, anything that uses your home for a place of business, I would say that that would be a violation.
Okay, so the issue is you've got outsiders coming to the home.
Yes, because
Okay,
that's
but-
what Craig's track talked about was the negative impact.
Right, but isn't your client renting it, or one of your clients are renting their property to somebody else? That's an outsider that's renting the home. I'm just trying to figure out where this line is. We all need to know where the line is.
But I don't know if you do need to know where the line is. And I agree with you, there is a line. And what I said earlier is I don't think it's disputed that people can rent their home. In Dr. Brandt's case, he was going to open up a hospital or help a hospital out in Minnesota. So he's there for a couple years, and he is renting his home to people who are living in it. They moved in. They live there. They go there every day. They pay the utilities. Their names are on everything. That's living.
Okay,
And that's different
so-
than somebody staying. And so we have to find the line.
So you
and
think that's country residential living?
Yeah, we're trying to
Yes.
figure out what that means.
Well, I think it's living.
They didn't tell us what it meant, right?
That's correct. I think it's living, and I'm just saying that I'm not sure this court should decide a bright line and say X number of days. I think it's going to be dependent upon the facts, what's going on in that subdivision up to that point,
So why isn't this a jury issue?
because I think it's contract interpretation.
Right, but I mean, the magic time being some days, right? I mean, why not throw that out to a jury?
Because I think the facts that are operative for this case to be resolved are not in dispute. And let me run down a couple of those facts, because what's important to me is that in this case, if you look at Appendix E and G, when you guys go back there, they're nightly rates. These people are renting their property out on a nightly basis. There is no limitation if you go to the VRBO or Airbnb website. Their rates range from $850 to $1,400 a night, depending on season. It says guests on the website. It says there's a, quote, check-in and quote, check-out date. In the 6 months, they got their permit in mid-2022. Just in the 6 months between June and December, they had 11 separate groups stay there over a period of 68 days, a minimum of 4 nights, a maximum of 9. They earned $55,000 in revenue and paid a management fee of $19,000.
Well, there's nothing wrong with them making money. I mean, you're acknowledging that they can have long-term rental. I mean, they'd make money off of that too, probably more than $55,000.
Yes, but long-term rentals have a rate that's commensurate with living arrangements elsewhere. If I'm going to rent from you...
Tell that to the people in Bozeman.
Yeah, true. Los Angeles. But yes, typically in most Montana communities, let's just say somebody that advertises for rent is going to rent their place out at a rate that's commensurate with other suitable living arrangements or comparable living arrangements in the valley, not $1,400 a night.
So Mr. Frampton, I don't really see how Craig Tracks, the conclusion in Craig Tracks, supports your position, and you said that it does repeatedly. But there is room in Craig Tracks for some of what you're describing, which is and where we're getting to, I think now, is that we have to look at the purpose, the residential purpose, and that the short-term rentals are not pursuant to a residential purpose. And that's the paragraph 10 of Craig Tracks, where the court went through all the jurisdictions that talk about what residential purpose are. And we did, in paragraph 13, say we agree with these jurisdictions. I don't know that I'd go as far as what you said in terms of adopting it. But I guess my question is that what you're suggesting that we do at this point?
What's that?
Adopt the jurisdictions that we've identified in paragraph 10, which we really didn't explicitly do, I don't think, in Craig Tracks. And that was the source of the district court saying, Craig Tracks is not clear.
If this court doesn't believe that it adopted it as a matter of law, then I am suggesting that. And here's why. It's what you need to protect the communities out there that have been protecting their own development, like my clients. If it is just eating and sleeping, if this court is not saying residential use requires duration, then the whole Craig Tracks means nothing, right? I mean, because wouldn't
Well, but Brown Drake's use of the property and the lodge, we allowed that and said that was consistent with the residential use.
I know, but if the court were, so let's talk about the conclusion in just a second. If the analysis were that one interpretation is eating and sleeping and a second interpretation is eating, sleeping, and duration, and therefore ambiguous, then wouldn't it just favor free use and allow Brown Drake to do that? But that is not where the court stopped its analysis. The court in Craig Tracks did not stop its analysis there. It actually said, we're going to look at extrinsic evidence. So that's why I believe paragraph 13 is actually saying, almost as a matter of law, didn't say those words, which says we agree it requires duration. And by the way, if you look at these other parts of our code, it too requires a duration.
Then how could you get to the conclusion then?
Because when you looked at the extrinsic evidence, the court went with the conclusion that they were allowed, again, on what I would call the big three. Number one, the covenants had removed its commercial prohibition. Number two, purchasers' expectations.
Right.
And in other words, I think what the factual evidence is really that people in the community were allowing short-term rentals already, right? So that's where, and the court even says on that point that it says it sheds, this is in paragraph 17, this prior use not only sheds light on the interpretation. And then the third thing was the use was consistent with residential use. In other words, there weren't negative impacts. So what I'm saying is the conclusion in Craig's Tracts isn't favorable. The analysis is. If we look at the analysis, we have the commercial use prohibition, which is more restrictive. We have, in this case, no prior use, and on 2 occasions, my client prevents the same home from using short-term rentals. On 2 prior occasions, they have protected their subdivision. And thirdly, there is nuisance, negative impact as submitted by all the affidavits.
And
right?
along those lines, Mr. Frampton, is there a separate provision in the covenants that prohibits nuisance or annoyance of your neighbors and that sort of thing?
There is, Your Honor, and that is in, oh, I thought there were, I'm not,
Paragraph 7. It's right underneath the signs prohibition. Is the clause that deals with nuisance.
yes, right there, paragraph 7. Thank you, sir. Yep.
I guess I have a question, piggybacking off that. When I look at Kleinhans, one of the big issue there was that the covenant specifically prohibited 2 residential structures on a lot.
Right.
And they violated that.
Right.
So that's what kind of brought about the fact that, oh, who's using this other lot? It's obviously for commercial. So you look at the structural requirements in this covenant. They haven't built an apartment. The one we just looked at, paragraph 7, they didn't build a trailer court, right? They haven't built a multifamily structure. So structurally, aren't those the guarantees this is a residential country living use if you follow that structure? Do those matter to us?
That it's just a single house, is that what you're saying?
Single house, as far as we know, it's one family and or friends at a time. They're not renting it to 5 different sub-units within that house. Aren't those all signposts saying that they're using it for residential country living?
I think it certainly goes to that, but I think you have to look at the actual use. So for example, could I rent the house out for an hour, 20 hours a day? I mean, is that allowed if there's no restriction? At what point does it become commercial use? That's the whole problem. So yes, it is a house, and yes, it has bedrooms and bathrooms, but at what point is the use, somebody not living there, but instead using it for a profit, and it becomes a commercial use? So,
But your other tenants that rent their property, presumably they're not renting at a loss, right? This isn't a rule saying you can't have profit, but you're pointing to this is a lot more profit compared to the neighbors.
yes, and I want to address that point, and I want to just say something in response to Ms. Gufson.
Yeah,
And
I don't mean to derail you from finishing her.
I want to finish one thought on the analysis of how the court got to there, and then I want to go back because I have an argument to make on that. And Ms. Gufson, so I talked about the fact that the purpose, the use, and then the commercial use prohibition, but then I want to say one other thing. There is a paragraph in there under paragraph 2, building types and use, and it says, any dwelling, that means the home, any dwelling erected or placed upon the property shall be used only as a private single-family residence, and no dwelling, building, or structure may be applied to, used, or occupied as an apartment or multifamily structure. So to go to intent, as you had asked, Justice Gustafson, we have any dwelling means the house. Private would indicate single use, not public use, not a public type use. And apartment, I think if you strictly construe it, it would be, they're trying to prevent transient use. They're trying to get people to live there and prevent transient use. And arguably, somebody that stays in an apartment stays longer than somebody that stays by the night or by the week. So for those reasons, I believe the court in its rationale was on page 5 of the opinion, lines 12 to 17. They found it ambiguous based on Craig's Tracts. They went to the language, and they determined the intent of the grantor was to prevent this type of use. Mr.
So what's the paragraph, I'm sorry, paragraph 2, what, this private single-family dwelling, no apartments?
Yes.
What's the paragraph number, sorry?
Paragraph number is
2.
It's on,
Are you talking of the covenant? 2A.
Paragraph 2, building types or uses.
yes, paragraph
Okay.
2A.
Okay, okay.
Okay, so, Mr. Swanson, or Justice Swanson, here's what I would propose. And to your point on Klein's, Myers versus Kleinhans, there is that argument to be made. Maybe in the future, I think for purposes of where we are today, the court decided Myers versus Kleinhans, saying that a short-term rental is a commercial use. It did not distinguish it based on the fact that it was an ADU versus a house. Those are definitely facts, and maybe down the court.
But Kleinhans, they had a structural covenant, and so first it kind of dealt with, violated that structural covenant, but
Right.
also the other, so.
And so, at some point, I believe the court may distinguish it on the basis that that was an ADU in addition to a house. Here, I would like to offer at least the court another approach to look at this. Just something to think about, maybe as part of your rationale. In my opinion, the problem with R&R's argument is that they're using very generic terms. Income, rental. Income applies to both long-term and short-term. Rentals applies to both short-term and long-term. How about looking at it this way? If somebody's renting it on a long-term basis, I don't think there's any dispute that that is residential living, right? Somebody's using it as a home to live there. And I also think it would be undisputed, as we mentioned earlier on the arguments with the other counsel, that a hotel is commercial use. So one way of looking at this is, which use is this closer to? Is this like a long-term type thing, or is this closer to a hotel? So let me offer this. The duration of a long-term lease is by the month, at least by month. That's by statute. It's month to month. Most contracts are half year, year, or more. However, a commercial use has nightly rentals. A hotel, you check in for the night or a couple nights. That's exactly the same situation we have here. The rates, as I mentioned to you, Justice Shea, are commensurate with other suitable, comparable living arrangements available in the Valley. Here, these rates far exceed any commercial rate available in the Flathead Valley. $850 a night is far higher than any hotel, and that's their minimum. 1,500 nights maximum. The use, one is somebody who's on a long-term rental would be living there. On a short-term rental, they're just staying a night or two.
So you would agree with the district court's 30-day as the cutoff?
In this case, under these facts, because that's what they were permitted. So as I had said in my briefs, I think it's going to be, as cases go forward, a factual basis. But in our county, you have to have a permit. The permit is for 30 days and under. So that's what we argued, and the court agreed should be what the commercial use is. And anything less than that is going to be that non-residential purpose and more of a commercial purpose.
So you could rent it out to 12 different parties over the course of a year on just a revolving basis. I mean, how many parties do they rent it out on a 5-day or 9-day? How many, and I know it's in here somewhere, I can't recall. I mean, how many people did, or how many different rentals did they do over the course of a year previously? If it restricted it to 12 times per year, does that meet the standard?
I don't think so, not in this case under these covenants, because it talks about living, and 12 different parties are just staying there. They're staying, they are not living there.
But that seems to contradict your position that a 30-day at a time rental would be okay.
I'm not saying a 30-day would be okay. I'm saying that they were permitted to 30 days, and the district court correctly said what you were permitted is in violation of the covenants. Let's just say hypothetically somebody stays there for over 30 days but less than 6 months. But they have this happen, I don't know, 4 or 5 times a year. Is that in violation of the covenants? I don't know. It'd have to be determined on a fact-by-fact basis to whether or not that type of use is violating the intent of the covenants at issue in that subdivision at issue. So in this case, the use has been from 4 days to 9 days. So if the court is having a problem with the 30 days, I think it can still resolve the issue and say the 4-day minimum to 9-day maximum is in violation of the covenants, and then, I guess, reverse on the 30 days. But I think the district court was saying if this is your permit, then that use is not going to be allowed under these covenants.
Kind of a slippery slope, isn't it, Mr. Frampton? And doesn't that give rise to an awfully lot of litigation in the courts?
It is, I think it might, but I think it's a factual basis, right? Because not every subdivision in Montana is the same. I mean, there are subdivisions that welcome these people. I've had a lot of calls from people saying we don't want them. I mean, what if people have allowed them and never stopped them before, and all of a sudden, you know, they start complaining? It all depends on the facts of each one. I mean, that's the problem. So I think at this point, we're just taking it step by step in how it goes.
Seems fraught with peril. I mean, I understand your argument. It's logical, especially between commercial and residential. But everyone agrees the covenants allow people to rent their house.
Yes.
I mean, how can a court step in to a set of covenants that doesn't have a durational covenant, restriction on that right and impose one based upon sort of a logical understanding we have about commercial use? I mean, it just seems like a lot to ask a court.
And to your point, sir, if that is what the court struggles with, then my argument would be that the court should affirm the ruling that the use that has existed to that point, 4-day minimum to 9-day, violates these covenants, and then reverse as to the 30-day hard line, if that's what the court's struggling with. Because the issue is R&R's use in violation of what's going on in this subdivision? That's the issue, and it is. And so the court finds. Back to the commercial use versus that. We refer to long-term renters as tenants. These are referred to as guests on VRBO. In a long-term situation, you might.
I mean, that's just a name. I mean, guests generally stay for free.
That's correct.
These guests are not staying for free.
Right.
They're paying money. They're really tenants, aren't they?
Yes, I think under the eyes of the law. But marketing, in a long-term rental, you might advertise and say my place is available, but you don't market it on commercial websites. Number of different people in a given year, you might have one on average, maybe just slightly more than that.
But again, so you're asking us to make a bunch of factual distinctions. That's our concern. Is
I'm just saying-
we're at summary judgment here without a lot of these issues being parsed out. So basically what we don't have is we don't have a definition from 1990 of what commercial means or what residential means, particularly what residential country living means. That's our problem.
Yeah.
Do you have anything more to illuminate us from 1990, what those meant at that time?
No, other than Craig's Tracts provides your analysis, because this same thing happened in Craig's Tracts. They were back in 1982 in a situation that we're dealing with in 2018, I think at the time. And so you follow the analysis, and that's exactly what the district court did. And you determine intent from the language and also from the extrinsic evidence. And if you follow the rationale and the analysis of Craig's Tracts, and you apply the facts of this case to the rationale that you guys set forth, it would go in our favor. And the final thing on commercial that I will say is that if we look at just two things, in the Montana Landlord-Tenant Act 70-24-104, it says that it doesn't apply to transient occupancy, like in a hotel or motel. And then if you go to the hotel motel code, section 50-51,
You can keep going.
102, it defines tourist home, and this seems right on point, a private home that is not occupied by an owner or manager and that is rented, leased, or furnished in its entirety to transient guests on a daily or weekly basis. So that's just a different way of looking at residential versus commercial. So anyway, that's all I have, unless somebody has questions.
Thank you.
Thank you.
Thank you. May it please the court, Stephanie Bacchus for the appellants. I think that I'd like to start on the last thing that council was talking about. Mr. Frampton was saying that, that the definition of country residential living does not exist in the covenants. And he obviously has a different understanding of what that means than my client does. But not having a definition is not a problem, because that's what this court can do, is interpret the contract. And there are very clear rules, 50-plus years of Montana Supreme Court jurisprudence regarding how to interpret those contracts. So I'd like to come back to that, but I think that if we follow the Craig-Trax rationale, it is clear that appellant's use is permissible. I think that council spent a lot of time talking about line drawing, asking you all to do considerable line drawing. There were distinctions I heard mentioned. I tried to write them down, and I'm now trying to read them because my handwriting is terrible. Regarding 30 days versus 4 to 9 days. Or maybe the distinction is customers coming to and from the home. Maybe the distinction is that hourly rentals would not be okay. Maybe the distinction, he's saying, is that the different rate structure of a short-term rental somehow makes it different. 12 months a year rental somehow makes it different. I think this underscores the problem. We should not be in a position of trying to draw all these lines. You don't have to do that to resolve this case. In the Craig-Trax case tells us, and the 50 years of jurisprudence from HEIDI tell us what needs to be done to resolve the case, which is that you look to the language of the covenants. If you find that the rental provision is somehow, rentals being allowed in the signage provision, allowing billboards and advertising for rent, if you find that to be creating an ambiguity when read in conjunction with the commercial and residential, then you look to the extrinsic evidence. Council agrees there is no contemporaneous extrinsic evidence. Friends of Lake 5 underscores what HEIDI had previously said, which is that it has to be contemporary. The post hoc, 30 years later evidence is not relevant. And so then you look to, after you don't find extrinsic evidence rather, then you would look to the principles of contract construction, and here is a classic ambiguity. I think these line drawing exercises are a red herring for what this court is doing today, which is interpreting the contract. I'd like to come back to the Craig-Trax residential v. commercial analysis.
So, counsel, your position is that there is an ambiguity, or is the construing the covenants together? You've got a commercial provision and a residential or a rental provision. Why can those be construed consistently so that there's no ambiguity? I guess, which track are you advocating the court take?
So after Myers v. Kleinhans, the analysis, I think, is slightly different. I think that I'm advocating that it's not ambiguous because there's no reference to duration in the contract. There's nothing that tells us how to draw those lines. And so I would say that it is unambiguous that rentals of any duration are allowed. However, understanding the court's analysis in Myers v. Kleinhans, I could see a reading that the covenants would potentially be ambiguous, and if that is the case, then you need to look to all the provisions together as a whole, not giving, not excluding one or more provisions. Reading them together, there is a way to harmonize them, and that is to prevent the rentals. Sorry.
So here, commercial excludes rentals. Is that how?
I do not believe that the definition of commercial from this covenant excludes rentals at all. I think that the Myers v. Kleinhans definition, because there were 5 or so definitions looked at in that case, because those covenants were different, right? There was nothing in the covenants otherwise that would have given you an idea that corporations could own property, or that rentals and billboards advertising for rent would be permissible. And there was nothing in there that talked about junkyards and feedlots and those things being excluded. I think that the covenants here are different, and I think that it's important to emphasize the principles of covenant construction. I think the Avon case from Connecticut gives some helpful language that underscores the statute that we have here in Montana about making sure to harmonize those provisions. So I hope that answers your question.
Well, I guess what I'm saying is that the covenant, if you look at the covenants and the construction of the covenants and not this court's, exclusively to that, we've got a commercial covenant and we also allow rentals. There's not any dispute that rentals are allowed. So I'm saying that if you construe the covenants consistently, there's an exclusion from commercial purpose that permits rentals.
Right, and it does not have a limit as to the duration.
And
so-
does not have, all right.
Correct, which is why I believe the covenants are unambiguous. But I think at a minimum, it creates the ambiguity. So that's the role that we believe is, at that time, extrinsic evidence or the lack thereof, and then following through on the analysis. Regarding Craig Tracks, I would say that the evidence there considered about the allowance of short-term rentals years later, they were, I believe you all, and I think Justice McGrath wrote the opinion in Craig Tracks, that was considered for what were the reasonable expectations of the owner. It was sort of an analysis about, the fairness and the reasonable notice that was provided. What did the owner understand? And I think that bears on the third point that I was trying to get to earlier, which is that the significance of this case can't be understated. I think if the district court's decision is not reversed, the case could have wide sweeping and destructive implications for Montana homeowners.
I mean, you both have just got done saying, we're interpreting the terms of these specific covenants, and we're trying to ascertain the intent of the original drafters. Each one is going to be different. And, in Craig Tracks, we looked at the fact that there was a prohibition against commercial use that had been deleted. We looked at the fact that the owners in that case lived on the property for a majority of the year. Those were all things, those were all specific, they were specific factors that we looked at in considering whether the short-term rental was allowed. We're gonna be faced with that in every case. So you kind of lose me on the widespread
So I think that
impact of a specific covenant.
I think that's terrific to hear that this court is going to analyze every covenant uniquely and look at the facts differently. I think the district court's analysis would lead to an overly broad, sweeping, interpretation of covenants and contracts. So that if the case is decided correctly, it will be consistent with all of the precedent that every set of covenants is different. They're all read on their face to harmonize the principles. You can't add to them. That is consistent. The district court's analysis was not, which is why we're asking you to reverse that decision. I think, the interest of the amicus parties in this case reflects how important these property rights are. Again, restrictive covenants are limitations on the free use of property. Thus, they need to be construed strictly. The Constitution provides for the protection of property rights in Article 2, Section 3. And the district court, unfortunately, foreclosed that right through nothing more than implication and sort of the imposition or the creation of a 30-day limit.
But the other parties have property rights too. And I get what you're saying, and I don't dispute that, but you don't elevate one's property rights to the exclusion of the other. We have our principles of interpretation, but if this was unambiguously saying there's no short-term rentals, no long-term rentals, whatever, they have a right to have the benefit of the covenants if in fact those covenants preclude that. Nobody gets, I get the tie goes to the runner and all of that, but we don't elevate one person's property rights over another.
Absolutely, and I think the set of covenants that we have here creates a good balance of that, and it does permit the rental use. I do want to comment on that line of thinking, Your Honor, that there is the covenant regarding nuisance. I think that they did not bring, I think that's A7 of the covenants, did not bring a challenge related to a nuisance. Additionally, the plaintiffs are not without recourse. There is an amendment procedure in the covenants. I think it is B4. And if the plaintiffs were to desire to change those covenants, they could. There are certainly hundreds, if not thousands, of residential covenants in the state of Montana. and I would say thousands. And then there are certainly dozens or hundreds that specifically address short-term rentals. The concept of a tourist home, which I heard counsel mention, is for a residential home. The definition of a short-term rental, which is in tax code that this court cited, I believe, is also for a residential home. I think that, you know, the definitions of tourist homes and the Landlord-Tenant Act also has numerous references to daily and weekly rentals. I think that these are distinctions that apply differently in different contexts. And here, we're in the covenants context, looking at the interpretation of this contract. So it's important to consider, what would a reasonable person know when reading these covenants? I think it is unreasonable to expect that someone would understand that a rental of 32 days is acceptable, but a rental of 27 is not. I think that is nowhere on the face of the covenants, and it
But
defies
really
reasonable
isn't the
expectations.
issue here, not 27 or 32 or whatever. I mean, we're talking, is it 4 to 9 days versus the 30, right? I mean,
So again, I don't believe that a reading of the covenants that is reasonable could differentiate between the number of days. I think that it contemplates that rentals are expressly allowed, and it does not have a durational limit. So the plaintiffs are asking you to write something into this set of covenants that does not exist, and that defies decades of, you know, contract interpretation and principles, certainly in the Craig Trax case as well.
But counsel, you don't dispute that the requirement of the covenants is residential?
Absolutely not. We
So
agree.
How do we fashion something going forward for the district courts that sets out what is or is not residential? I mean, that's the problem.
Right, and I
Do
don't.
we have cases over and over again, and a judge deciding, yes, this family or these people are inhabiting this home for a residential purpose? Do we really want to go down? I mean, how do we do that?
So I don't think that you have to. I think that you look at different cases in this court's history, like Tipton or Micklin, I believe. There's two cases about garages. You know, those garages, one was a commercial in violation of the covenants, and one was found to be residential. I think that in this case, you are looking at the terms of the contract, and you have sort of unique language, right? They talk about country residential living, but yet they talk about a corporation being able to own that property. They talk about, you know, no commercial trade manufacturer, but then they contextualize that with language about junkyards and wrecking lots. I think that it is an exercise of policy making that they're asking you to do. They're asking you to create a definition that does not exist in the covenants. What we can do is understand what is contemplated by the covenants, and that's all the that's all appellants are asking you to do. I think that some of the examples brought up during Mr. Frampton's argument are really significant here, because if you were to affirm the district court's decision, you would be upsetting the apple cart, or the bundle of sticks, if you will, of property rights in covenanted communities pretty much overnight. If you were to accept that analysis, you would be turning property rights on its head. Thousands of Montanans live in residential covenanted areas. Many, like myself, work from home. If I stay up until 1 a.m. in the morning preparing for this argument, which I have done, not last night, but a different night, then I would potentially be in violation of my residential covenants. But you'd have to look at the covenants. You'd have to read each set of covenants uniquely to determine if that particular use was allowed. I think that they're asking you to make a broad brush argument that would not let my kids go out and sell lemonade, although my kids just sold water this past summer. You know, they would ask you to do something that is a line drawing exercise that you don't have to do. I think that it's too difficult to draw those lines, because this court's function is not to draw those lines. Just because an activity receives income or is subject to tax, that doesn't change the primary purpose of the use. Again, those are different contexts, taxation versus covenant use and the provisions of those covenants. I think the district court's analysis would put every homeowner at risk anytime income happens to be generated on their property. But in this case, when you have a rental of 5 days or more, the renter uses that property just as the owner does. And the Craig Trax case analyzes, you know, a number of cases from other jurisdictions that is helpful. And I do believe that if you take the Craig Trax case and follow that, if you do find an ambiguity, then you're in the space of Craig Trax, right? And if you find that ambiguity, then it's clear about the covenant construction rules. You have to look to the specific language and the situation of the parties. I think the statutes 1-4-102 about looking at the face of the covenants is useful. I think 38-3-303 is also useful about, you know, understanding what the circumstances were at the time of drafting. So I think in conclusion, there are 3 reasons that that we believe this case should be decided as should be reversed. The covenants do expressly contemplate rentals. There is no durational component. Parties agree on those facts. This position, the appellants, is consistent with Craig Trax and its progeny, including Myers v. Kleinhans. The implications of the affirmation would be catastrophic, and applying Montana law and the correctness standard of review to the undisputed facts here, the outcome is straightforward. Court should reverse the judgment and ensure that covenants are construed on their own specific terms in every case, and that the tie in Montana continues to go to the free use of property. So I think it's crucial that the court go back to these contract principles. And I would just like to close with a little bit of an examination of the residential versus commercial covenants. In Craig Trax in 2020, those rentals in that case, it was a fishing lodge. There were 3 available units for any given rental that was owned by a group of owners. One of them, I think, did stay on the property somewhat. This case is easier. This case is one single-family residence. The residential use is even more apparent. When we look at the ADU rental above a garage, that is in Myers v. Kleinhans. That's a different nature, right? That is a different type of rental. And in Friends of Lake 5, another case that involved, I think, up to 70 people renting the property at any time, again, that's a different type of use. But you don't have to get to that line drawing to rule for the appellants. The use in their case is a quintessential residential purpose. I think it might warrant saying that I think the appellees' reading of Craig Trax as having, you know, agreed with the line of cases that imposed a durational limit, I think that was paragraph 12, is not correct. That was something that this court considered and then decided that because it found an ambiguity, would conduct additional analysis. So I think that misreading of Craig Trax, which the district court also did, contributed to the errors that were made at the district court level. So it's significant that everyone agrees that long-term rentals are allowed, and the features of the long-term rental, you know, appellees make much of the ability to advertise on a national website, or having a property manager, or earning income. But all of those features are equally available to a long-term rental. I rent out my mother's home for her in Tennessee. We have a property manager, advertised on a website, it earns income. There is no distinction that the covenants provide, and imposing such a durational component on those covenants would be an unfair reading and subject the entire population of Montanans in residential covenanted communities to a standard and a burden that is inconsistent with the prior 50-plus years of jurisprudence. So thank you for your consideration. We appreciate being able to come here today and talk with you about these important issues. So thank you.
Thank you, counsel. Thank you both. The matter is submitted.
Oh, thanks. I'm just making a mess all over the place.